Greetings for the day. I am Assistant Professor Reenudat at BBDU University. Today's topic I'm going to teach is definition and meaning of torts. To start with the topic, nature of torts. First and foremost, as we all know, that tort is derived from the Latin term tortum, which means twisted. The term is French equivalent of the English word wrong and the Roman law term delict. It implies a conduct which is twisted or wrong. Basically, law of tort is a body of obligations and remedies that is applied by courts in civil proceedings to provide relief for persons who have suffered harm from the wrongful acts of others. To firstly give the definition was given by Selman, which states torts as a civil wrong for which the remedy is common law action for unliquidated damages and which is not exclusively the breach of contract or the breach of trust or other nearly equitable obligations. The second definition given by Winfield, which says tortious liability arises from the breach of a duty primarily fixed by law. This duty is towards persons generally, and its breach is repressible by an action for unliquidated damages. To explain the nature of torts, we have to compare it with other forms like crime, contract, and breach of trust. Now, the difference between a tort and a contract can be discussed as follows. Firstly, if we consider it in contracts, the parties with their free consent undertake to perform certain duties, while in tort, the duties are imposed by law. Now, secondly, if we consider contract, the contracting parties owe duty to each other only. The duty they owe is to each other only. A duty not to commit a tort is owed to persons generally and not to any particular individual. So basically, it is the person who is committing the tort owes the duty to other persons, not to any particular individual. Also, a tort is different from breach of trust. As in tort, the damages are unliquidated, but in breach of trust, they are liquidated as they are ascertainable before the beneficiary brings an action against the trustee. Essentials of tort. Now, what constitutes a tort, or what are the essentials to commit a tort? First is act or omission. To make a person liable in tort, he must have committed some act or omission in the performance of his legal duty. For example, entering someone's property without any justification or defaming a person of his reputation. These acts result in torts of trespass and defamation. Next is legal damage. To be successful in an action for tort, the plaintiff has also to prove legal damage or an injury. Unless there is a violation of a legal right, an action under the law of torts cannot lie. Essentials of tort. Now, if we consider what are the essential elements to commit a tort or what constitutes a tort, first and foremost, an act or omission. To make a person liable in tort, he must have committed some act or omission in the performance of his legal duty. Now, if we give an example, it's that entering someone's property without any justification or defaming a person of his reputation. Now, these acts result in torts of trespass and defamation. So, this means there must be some kind of act or omission of duty on the part of defendant or the wrongdoer. He must have done something that he was not expected to do, or he omitted something which he was expected to do, and that act or omission must have affected the legal right of another person. Secondly, if we consider the next essential, it is legal damage. Now, to be successful in an action of tort, the plaintiff has also to prove legal damage or injury. Unless there is a violation of a legal right, an action under the law of torts cannot lie. Now, this means that the act or omission must be required by the law, and the duty to perform them must be imposed by the law. If there is a mere social or moral wrong, then there would be no liability for tort. In other words, we can say that there should be a legal injury or invasion of the legal right. Now, in absence of an infringement of legal right, a tort does not arise. Also, where there is only an infringement of legal right and no legal damage, still the action of tort arises. Now, the legal damages are of two types, as we discussed. First is injuria sine damno. This means a violation of legal right without causing any damage to the other person. Since there is a violation of a legal right, it is actionable even without proof of damage. A landmark case will help better understand this principle, that is Ashby versus White, where the plaintiff was stopped from casting his vote by the defendant. In this particular case, the defendant, a returning officer in an election, wrongfully refused to take the vote of the plaintiff, an eligible voter. The plaintiff did not suffer any loss initially by this refusal, as the candidate for whom he wanted to vote won the election. The defendant was, however, held liable because the plaintiff's legal right had been violated. The cancellation did not affect the election, but it affected the legal right of the plaintiff, causing him legal injury. So he would be entitled to sue the defendant for the tort committed. Now, next is damnum sine injuria. Now, this means causing damage without the infringement of a legal right. Unless there is an infringement of a legal right, mere causing damage isn't actionable. Now, this case of Gloucester Grammar School will further better explain you this principle. In this particular case, the defendant set up a rival school to that of the plaintiffs. Because of the competition, the plaintiffs had to reduce their fees from 40 pence to 12 pence per scholar per quarter. It was held that plaintiffs had no remedy for the loss that thus suffered by them. So, this means that though whether mental element is of any relevance in tort, generally under criminal law, mens rea or a guilty mind is a necessary element for liability. But the same is not the case with law of torts. Torts such as assault, battery, false imprisonment, deceit, malicious prosecution and conspiracy require the state of mind of a person and are relevant to ascertain the liability while torts such as negligence or defamation do not require a mental element, and thus it is completely irrelevant. Now we consider types of damages. First is nominal damages. Now nominal damages are awarded in cases where there is injury without a loss, say the act of trespassing. Here a token amount or nominal amount is awarded. Next is compensatory damages. Now in this compensation is provided. Next is punitive damages, and next is contemptuous damages. These damages are awarded when the plaintiff moves the court on a technical legal ground without moral justification. The courts express their disapproval of such conduct by awarding a very low damages of say ₹1 or even paise.